Assalamualaikum and hi, my name is Umi Syabatul Jannah binti Mahta. I am from Kelantan but I live in Selangor. For my education background, I was a student in the UiTM Law Foundation and now pursuing law degree in UNIZA. Everyone has their own ambition that they want to achieve, right? So, when I was in my secondary school, my only thoughts at that time is to get flying colours results in SPM. But after some motivating words from my parents to try pursuing law, so I did got in the law foundation. And when I was studying law foundation, I gained a lot more interest in studying law as I experienced a lot of fun things. And studying law has changed my mindset towards the norms of this path. So to continue this video, I will be giving my opinion towards the question of this task. My answer for the question given is firstly, the issue here is whether the response of Atika's acceptance fulfill the conditional offer or not. According to Section 6C of the Contract Act 1950, a proposal is revoked by the failure of the acceptor to fulfill a condition precedent and acceptance. Moreover, in Section 7B of the Contract Act 1950 states that the acceptance must be expressed in some usual and reasonable manner. In this case, during the negotiation phase, Andika offered to sell the album to Atika on the condition that the acceptance be made through only WhatsApp before on June 20, 2022. When Atika called to accept, she claimed that Andika had broken the contract. Andika stated that when he offers the album, he wants the acceptance to be via WhatsApp rather than calling him. But Atika called him and does not follow the condition made by Andika. In conclusion, Atika's acceptance cannot be accepted as she does not follow the condition of the offer made by Andika. In addition, the second issue for this case is whether the revocation of the offer made by Andika to Atika is valid or not. In Section 4.3b of the Contract Act, the communication of revocation is complete as against the person to whom it is made when it comes to his knowledge. It doesn't matter if the offerer does not have the knowledge that the offeree knows the revocation of the offer that has been made by them, as long as the offeree is aware about it and the revocation of the offer has been completed. This also can be seen in the case of Dickinson against Dodds, where Mr. Dodds, the defendant, wrote to Mr. Dickinson, the complainant offering to buy his house for €8,000. He promised to keep this offer available to him until Friday. Mr. Dodds, on the other hand, accepted an offer from a third party on Thursday and sold his house to them. It was claimed that Mr. Dickinson was going to accept this offer but had not told Mr. Dodds because he knew he had until Friday. Mr. Dodds informed the complainant that the offer had been withdrawn via a friend. Mr. Dickinson went to find the defendant after hearing this and explaining his acceptance of the offer. The complainant brought an action for specific performance and breach of contract against the defendant. The court determined that Mr. Dodds' statement was nothing more than a promise and that no binding contract had been formed. He had made the complainant an offer to purchase his home, which he might resign at any time until it was accepted. This scenario could not be changed without a deposit. As a result, there could be no meeting of the minds between the parties because there was no responsibility to keep the offer available. Furthermore, the court held that a message from a friend or other third party that an offer had been withdrawn was valid and would be handled as if it had come directly from the person. In this case, even Andika did not state about his revocation of offer. With the knowledge of Atika about the album that has been sold from her best friend, it shows that the revocation of offer by Andika has been completed. Also, Atika's acceptance of the offer is invalid. In a nutshell, the revocation of the offer made by Andika is valid.